It started with an ordinary traffic stop. San Diego, August 2009. Police pulled David Riley over for expired registration tags. What happened next would eventually force the Supreme Court to answer a question the Constitution's authors could never have imagined. Riley was arrested, and police took his cell phone. But this wasn't just another object in his pocket. Inside that phone were photographs, messages, contacts, and videos, pieces of a person's private life. The officers searched its digital contents without first getting a warrant, and that raised a much bigger question. Does an arrest give police the right to search your digital life? In 2014, the Supreme Court gave a remarkably clear answer, and that answer changed digital privacy in America. But to understand why the court reached that answer, we need to go back to the traffic stop and look at what actually happened. When the officer stopped David Riley, he discovered that Riley was driving with a suspended license. Under department policy, Riley's car was impounded. And during an inventory search of the vehicle, police found 2 handguns hidden under the hood. That discovery changed everything. Riley was arrested on weapons charges. During a search incident to that arrest, an officer found a smartphone in Riley's pants pocket. The officer didn't simply take the phone and secure it. He accessed the information stored inside, and what he saw immediately caught his attention. Some entries on the phone contained letters the officer associated with the Blood Street gang. But the search didn't end there. About 2 hours later, at the police station, a detective who specialized in gangs examined the phone again, this time looking more deeply through its digital contents. He found photographs and videos. Among them were images connecting Riley to a car police suspected had been involved in a shooting several weeks earlier. The phone had transformed from something found in Riley's pocket into a source of evidence in a much more serious criminal investigation. Riley was eventually charged in connection with that earlier shooting, including attempted murder and firearm offenses. Prosecutors also alleged that the crimes were committed for the benefit of a criminal street gang, and evidence taken from his phone became part of the case against him. Riley challenged the search. His argument was straightforward. The police had searched the digital contents of his smartphone without first obtaining a warrant. The trial court rejected that argument. Riley was convicted, and the California Court of Appeal affirmed. Now the dispute was no longer simply about what police had found on one man's phone. It was about something much larger. Does arresting someone give the government the power to open a smartphone and search through the digital record of that person's life without a warrant? The case eventually reached the United States Supreme Court, and Riley's case wasn't alone. The court considered it together with another case, United States versus Worry. Worry involved a different arrest and a different kind of phone, but the constitutional problem was essentially the same. Could police search digital information on a cell phone seized during an arrest without first obtaining a warrant? The government relied heavily on the traditional search incident to arrest doctrine. The argument was straightforward. Police have long been allowed to search objects found on an arrested person. A phone is an object found on an arrested person. So why should a phone be treated differently? Riley's side argued that this comparison ignored what a modern phone actually is. A cigarette package might contain a handful of physical objects. A wallet might contain identification, receipts, photographs, and cards. But a smartphone can contain enormous quantities of information about nearly every aspect of someone's life. The old rule had collided with a new technology, and the Supreme Court had to decide whether the Constitution treated them the same. Chief Justice John Roberts wrote the court's opinion. The analysis returned to the 2 traditional reasons for allowing a search incident to arrest: officer safety and destruction of evidence. Start with officer safety. A physical object can potentially conceal a weapon. So police may examine the physical phone itself For example, an officer does not have to ignore the possibility that something dangerous might be concealed in or around the device. But digital data is different. A photograph cannot attack an officer. A text message cannot become a weapon. A contact list cannot help an arrested person physically escape from police custody. Once the phone itself has been secured, searching its digital contents does little to protect the arresting officer. That weakened the first traditional justification. Then came the second, evidence preservation. The government warned about remote wiping, someone elsewhere potentially deleting information from the phone. It also raised concerns about encryption. But the court was not persuaded that those general risks justified giving police a categorical power to search every arrested person's phone without a warrant. The Fourth Amendment normally requires something more than a generalized possibility, and when a genuine emergency exists, another doctrine may already provide the answer: exigent circumstances. But this is where Riley became much bigger than a technical case about police procedure. The court recognized that smartphones are fundamentally different from the ordinary physical objects traditionally found in someone's pockets, not merely because they contain more information, but because they contain information of a completely different scale and character. Think about what a phone can reveal: years of photographs, thousands of messages, contacts, internet searches, videos, calendars, financial information, medical information, location history, personal notes, private relationships, a person's interests, their associations, their habits, their movements, and individual pieces of information can become far more revealing when combined. A single photograph might tell police very little. Thousands of photographs organized across several years may reconstruct an entire life. A single location might mean nothing. A history of locations can reveal where someone sleeps, where they work, who they visit, and potentially what they believe. That was the constitutional difference. Before smartphones, practical physical limits restricted how much information a person could carry. A person could not realistically walk around with every letter, photograph, book, diary, map, and personal record accumulated over years. A smartphone changed that. The court described modern phones as, in effect, mini-computers capable of performing countless functions beyond making calls. The technology had changed, but the privacy protected by the Fourth Amendment had not disappeared. On June 25, 2014, the Supreme Court announced its decision. The judgment was unanimous as to the central result. Police may seize a phone from a person who has been lawfully arrested. They may secure the device. They may examine its physical aspects when necessary for safety, but as a general rule, they may not search the digital information stored on that phone merely because the owner has been arrested. For that, they need a warrant. Chief Justice Roberts closed the court's analysis with a remarkably simple instruction. Before searching the digital contents of an arrested person's phone, get a warrant. Riley had drawn a constitutional line between possessing the device and opening the digital life contained inside it. Riley did not create an absolute rule that police can never search a phone without a warrant. The court specifically recognized that genuine emergencies may justify immediate action. The legal doctrine is known as exigent circumstances. Imagine police reasonably believe that someone is in immediate danger, or officers are confronting an active threat, or there is a real and urgent need to prevent the imminent destruction of evidence. Depending on the facts, the Fourth Amendment may allow a warrantless search. But notice the difference. The rule is not, you were arrested, therefore police may search your phone. After Riley, the general rule is, get a warrant. If police want to proceed without one, they need a recognized exception to the warrant requirement that fits the circumstances. That distinction matters. Riley versus California became a landmark. Because the court did something that constitutional law repeatedly has to do: apply an old constitutional protection to a technology the founders could never have imagined. The Fourth Amendment was written centuries before smartphones, but the principle behind it was never limited to 18th century technology. The question is still about government power and the private sphere the Constitution protects from unreasonable searches. Today, our phones may contain more information about us than our homes once did. They remember where we've been, who we've spoken to, what we've searched, what we've photographed, what we've written, and sometimes, what we've forgotten ourselves. Riley recognized that placing all of that information inside a device small enough to carry in your pocket does not automatically make it fair game for the government. Technology changed the container. The Constitution still protects what is inside. So if police arrest you, can they take the phone from your pocket? Yes. Can they secure it? Yes. Can they automatically begin searching through its digital contents simply because you were arrested? Generally, no. The rule from Riley is simple: get a warrant. And that one sentence helped redefine privacy for the smartphone age. This is the Law Decoded, where the cases that shaped American law become understandable.